What is the difference between DUI per se and DUI less safe? That's a great question. Oftentimes you're going to see someone charged with both of these when they're charged with DUIs in Georgia, and today I am going to discuss the differences between DUI per se and DUI less safe. And it's going to kind of just be a discussion from a 10,000 foot view, if you will. Make sure you're talking to your lawyer about the differences, whether you can be charged with both, convicted of both, and what that looks like in your case, because everybody's case is a little different. But let's start with DUI per se. This is probably the one that more people know about. It's a little more common. People tend to know the number associated with DUI per se. So in Georgia, 0.08, that's the big number, right? Everyone wants to know, did you blow? Did you give blood? Was it over a 0.08? Was it below a 0.08? Those are the big questions. So the question used to always be, did you blow? Did you blow? Did you blow? Did someone do the breathalyzer, the intox machine at the jail? As the laws have developed in the realm of DUI defense, law enforcement tends to ask for blood tests more now than breath tests, but the number is the same. The per se limit, meaning that if the law presumes that if you are a 0.08 or higher, that you were too drunk to drive your vehicle. So that's what we're talking about there. Do they have a number? Do they have a blood test? Do they have a breath test? Do they have a scientific test that puts you at a 0.08 or higher? Because if so, it makes the case more difficult to defend, and we're going to have to start looking at, are there any ways to attack this chemical analysis, or are we in pure mitigation mode? Okay, so that's a DUI per se. Do they have a chemical test of blood or breath that puts you at that 0.08 or higher? Next, DUI less safe. This one is trickier. It's a better case to defend, and it is a much more triable case where we can say, hey, you know what? We don't like your offer, Mr. or Mrs. Prosecutor. We want a trial. Okay? A DUI less safe is where they may not have a blood test. They may not have a breath test. Or if they do, it's under the 0.08 level. So DUI less safe just means, hey, even though we don't know if you were 0.08 or more, we're saying that you were under the influence of alcohol to the extent that you are a less safe driver. So, hey, Jimmy, you had a beer. Because of that beer, you're a less safe driver. And this is where people have a giant misconception. They think that as long as they're under that 0.08 level, they can't be charged with DUI. If they are, it's an automatic win. That's not true. We see prosecutors routinely, especially in Coweta, go forward on DUI cases where there's either not a number or the number's below a 0.08 on this less safe theory. Hey, someone had alcohol in their system. Because of that alcohol, they were a less safe driver. Therefore, we can prosecute them for a DUI. The law allows that. The law allows for them to pursue that theory, but it is a much more defensible case. That's the big difference between DUI per se and DUI less safe. Make sure you're talking to your lawyer about it, because oftentimes you're going to see it charged both in one accusation. Subscribe here for more information, and if you have a question about your case, call us at 470-635-1725.